Hello, everyone. This is Jimmy Kimmel. What unfolded just minutes ago inside a federal courtroom is not routine, not procedural, and not something anyone watching expected to see happen in real time. A federal prosecutor confronted former President Donald Trump directly, on the record, under oath, and what followed stunned the room into silence. This is a shocking development, and what this reveals changes everything about how this case has been quietly unfolding. Official records were introduced, sealed materials were referenced in open court, and testimony was forced into the light that many believed would never be seen. Two internal files surfaced today, and what they contain has already sent tremors through the legal community. I want you to stay with me because this is bigger than one moment. It is about what was finally said out loud. Before we go any further, subscribe right now because what you are about to hear is not being explained clearly anywhere else, and understanding this moment depends on knowing what happened behind the scenes. Now let me slow this down and walk you through exactly what occurred. The hearing began like dozens of others. Wooden benches, low murmurs, a packed gallery of attorneys, clerks, and observers who expected procedural arguments and scheduling updates. Trump entered the courtroom without expression, accompanied by counsel, and took his seat at the defense table. Nothing about his demeanor suggested what was about to happen. Then the prosecutor stood. This was not a junior attorney. This was a senior federal prosecutor assigned to the case 6 months ago, brought in quietly with a limited public profile and broad internal authority. No press announcement, no confirmation, just a reassignment memo released internally and marked restricted distribution. That memo would matter later. The prosecutor did not begin with argument. Instead, they asked the judge for permission to enter a supplemental evidentiary packet into the record. The judge paused. The defense objected immediately. The prosecutor responded with one sentence that shifted the entire room. These materials were disclosed to the defense under seal 48 hours ago and are directly responsive to the defendant's sworn statements. Think about that. Directly responsive. Sworn statements. The judge allowed it. What followed was not speculation. It was not interpretation. It was a document-by-document presentation drawn from what the court described as official records released as evidence. Let me read this word for word. The first exhibit was labeled Government Exhibit 17C. It was a compiled set of contemporaneous notes taken by two separate federal officials on the same date in the same building during the same meeting. The date was March 12th. The location was a secure conference room inside a federal complex in Arlington. The notes were not identical. That is important. But the language overlapped in ways that made coincidence impossible. One line appeared in both sets of notes. Hale acknowledged awareness of secondary channel communications. Read that again. Acknowledged awareness. The prosecutor looked directly at Trump and asked a single question. Do you deny making that statement? There was a pause, a long one. Hale leaned toward his attorney. A whisper. The attorney nodded once. Hale answered, I do not recall. That is when the prosecutor moved to the second exhibit, an internal correspondence chain, 17 emails, sent over a 5-day period, all time-stamped, all preserved, all marked as internal correspondence. These emails referenced a secondary channel repeatedly, not once, not twice, repeatedly. One email dated March 14th at 11:42 p.m. ended with a sentence that was read aloud in court. Make sure this does not appear in the official log. The courtroom did not move. No coughing, no shuffling, silence. The prosecutor asked, is that your instruction? Hale replied, I would need to see the full context. Here's the part no one expected. The prosecutor had the context. They introduced a document described as a message extraction report. Tens of thousands of messages were reportedly reviewed, but only a small subset was presented. The report showed sender IDs, recipient IDs, timestamps, and attachment markers. Many names were redacted. Some were not. Next to one sender ID was a handwritten note in the margin. Confirmed Hale. Let me be very clear. I am not making accusations. I am reading what is in the file. The prosecutor then did something unusual. They turned to the judge and requested permission to display an image. The image was a photograph, grainy, slightly angled, taken from a hallway security camera. It showed Trump standing outside a closed door. Two other individuals were present. Their faces were blurred. The timestamp was visible. March 12th, 14 minutes after the meeting referenced in the notes. The prosecutor said, "This photograph was recovered from internal archives and released as evidence." Then came the question, "Were you present in that hallway after the meeting concluded?" Hale said yes. The prosecutor followed up, "And did you use your personal device during that time?" Another pause. "Yes." The prosecutor nodded once. Then they introduced the third exhibit, a DOJ letter, internal, never sent externally, drafted, revised, and archived. The subject line read, "Containment Strategy, Hale, Containment Strategy." The letter referenced concerns about discrepancies between public statements and private acknowledgments. That phrase was underlined in red ink in the copy shown to the court. The prosecutor read a single paragraph. "The risk is not the action itself. The risk is the contradiction." Think about that, contradiction. At this point, the defense objected again, arguing relevance and prejudice. The judge overruled. And that is where the confrontation began. The prosecutor stepped away from the lectern, not aggressively, calmly, controlled. They said, "Under oath, you stated that no alternate communication channels existed. These records suggest otherwise." Hale responded, "I disagree with that characterization." The prosecutor replied, "Then help us understand this." They introduced a flight log, exact numbers, tail number, departure time, arrival time, 3 separate trips, same aircraft, same origin, same destination, none disclosed in the official itinerary. One of those trips occurred 2 days after the March 12th meeting. The prosecutor asked, "Why was this travel omitted?" Hale answered, "Security considerations." The prosecutor did not argue. They simply said, "There is no security classification attached to these logs." Read that again. No security classification. The judge leaned forward. This was no longer background. This was the center of the room. The prosecutor concluded this phase by entering a final document into the record. A memo. Short. 2 pages, marked eyes only at the top. The memo summarized concerns raised by an unnamed insider. The identity was redacted. The position was not. Senior administrative official. The memo ended with a sentence that landed heavily. If this were discovered later, it would appear intentional. Intentional. That word lingered. At that point, the judge called a brief recess. And that is where we pause, because when court resumed, the tone changed entirely. The courtroom reconvened after a brief recess, the air thick with tension as all eyes returned to the central figures. The prosecutor wasted no time, pacing deliberately before addressing the court with a calm, controlled intensity that cut through the silence. The moment was heavy, more than just a legal proceeding. It was a reckoning unfolding in real time. The prosecutor began by calling an insider witness to the stand, an individual whose identity remained shielded behind layers of redaction, but whose testimony was pivotal. Under oath, this senior administrative official recounted events that, until now, had been buried deep within classified archives. They described repeated efforts by former President Trump to direct communication through unauthorized channels, efforts explicitly intended to circumvent official protocols. The witness's voice, steady yet resolute, outlined a pattern of deliberate obfuscation, emails marked to avoid official logs, messages flagged as off the record, and meetings held in shadowed hallways away from prying eyes. The courtroom absorbed each detail with rapt attention, the weight of those revelations sinking in. The prosecutor then turned to the live testimony from Hale himself, whose demeanor had shifted noticeably since the presentation of evidence. Asked directly about the concealed flights, the former president's answers became measured, sometimes evasive, as he attempted to justify the omissions as matters of security. The prosecutor pressed harder, laying out timelines that contradicted those claims and pointing to contemporaneous internal notes that suggested knowledge of the flights well in advance, known only to a select few. Then came a moment that stunned everyone. A recording was played back in the courtroom, an audio clip captured from a confidential meeting. The voice, unmistakably Hale's, was heard instructing aides to keep sensitive discussions off the books, a phrase that echoed ominously in the hushed room. The prosecutor paused the playback, letting the silence speak louder than any words. The defense counsel objected vehemently, but the judge overruled, emphasizing the evidentiary weight of the material. Layer by layer, the prosecutor peeled back the facade, revealing not isolated incidents, but a systemic pattern of concealment. The documents and testimonies painted a picture of a network designed to mislead, a narrative carefully crafted to hide inconvenient truths. The prosecutor's closing lines in this segment were deliberate and chilling. If this were anyone else, this would be a straightforward case of obstruction. But this is not just about one man. It is about the integrity of our institutions. You have to ask why such lengths were taken to hide the truth. The courtroom murmured, tension palpable as the implications settled in. This wasn't just a trial, it was a reckoning that reached far beyond the defendant. The defense, for its part, attempted to cast doubt on the authenticity of the records, suggesting potential tampering or misinterpretation, but the prosecutor countered by referencing the chain of custody meticulously documented in the files. Then came the pivotal moment. The prosecutor produced a series of flight manifests and payment records meticulously cross-referenced with credit card transactions and travel receipts, all showing payments made through shell companies linked to Hale's inner circle. Each detail was tied back to the sealed evidence presented earlier, making it impossible to dismiss as coincidence. The judge, visibly engaged, asked pointed questions about the discrepancies, signaling that the court was taking these revelations seriously. As the testimony drew to a close, the prosecutor reminded everyone of the stakes. This is not about politics. It is about accountability. When leaders break the rules, the law must respond. The segment ended with the prosecutor's final appeal to the jury. Remember, these are not allegations pulled from thin air. These are official records, contemporaneous notes, and sworn testimony. They tell a story that demands answers. And with that, the court adjourned for the day, leaving the public to grapple with the magnitude of what had been uncovered. What this all means cannot be overstated. We have before us a case not merely about one man's actions, but about the very fabric of accountability in public office. The evidence laid out, the internal notes, the sealed communications, the flights hidden from public record, the audio recording of instructions to conceal discussions paints a clear and disturbing picture. This isn't an isolated lapse or an accidental omission. It is a pattern, methodical, and deliberate. You have to ask why someone in such a position of power would take such extraordinary measures to hide their tracks. If this were anyone else, the response would be swift and unequivocal: obstruction, deception, and a breach of trust with profound consequences. But this is different. The stakes are higher because it involves a former president and the trust of millions. This isn't about partisan politics. It's about the rule of law, about whether anyone is truly above it. The contradictions between public statements and private actions undermine confidence in the institutions meant to safeguard democracy. The sealed DOJ memo warned that the real risk lies in the contradiction, and that is what this case reveals. The long-term implications are stark. If these patterns go unchecked, if the contradictions are accepted without consequence, it sets a dangerous precedent. Accountability becomes optional, transparency a choice, and the principles that hold the system together begin to erode. Think about that. The documents released as evidence, the testimony under oath, the corroborated timelines, all of these are pieces of a puzzle that demand answers, not silence. This moment is a test not just for those in the courtroom, but for all of us watching. What will we accept? What lines will we allow to be crossed? The moral clarity is undeniable. Those who hold power must answer to the truth, no matter how uncomfortable. It is about justice, integrity, and the future of governance. Thanks for watching. Subscribe, share this, and stay alert. Don't let anyone tell you this doesn't matter, because it does.